Good afternoon, and welcome to the Federalist Society's Seat at the Sitting for January. I'm Elizabeth Slattery, Director for Practice Groups. For today's program, we've put together a great panel of legal experts to preview the oral arguments at the Supreme Court this month. This panel will cover the cases and then take audience Q&A in 90 minutes or less. As usual, our usual disclaimer applies. The Federalist Society does not take positions, and all views expressed in this session belong to our speakers. It's certainly a pleasure to welcome our moderator, Tiffany Bates. Tiffany is an associate at Consovoy McCarthy. She previously clerked for Judge Kyle Duncan on the U.S. Court of Appeals for the Fifth Circuit. She also previously worked in the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation, where she researched a variety of constitutional issues and served as co-host, along with yours truly, of the podcast SCOTUS 101. Tiffany is a graduate of Hillsdale College and the Antonin Scalia Law School. Complete bios for all of our panel are available for your review in the Zoom Resources tab or on our website. Towards the end of the webinar, we'll open it up to the audience, so please start thinking about your questions for the panel. Questions can be submitted with the Q&A function at the bottom of your screen in Zoom. With that, Tiffany, please take it away.
Thank you, Elizabeth, and thank you to the Federalist Society for hosting this panel. The court will hear 7 arguments in January, and it's set to be a blockbuster sitting. I'm delighted to introduce our all-star panel. For the sake of time, I'll keep these introductions very short. Brad Benbrook has over 25 years of litigating business and public policy matters across the country, representing individuals, companies, and advocacy groups and industry associations in constitutional and public policy litigation. After law school, he clerked for Judge Edmondson on the 11th Circuit. Stephanie Freudenberg is counsel at Sher Jaffe and has represented a broad range of public and private clients in complex commercial litigation. Stephanie clerked for Judge Kugler on the District of New York and Judge Clement on the Fifth Circuit. Jacob Hubert is Senior Litigation Counsel at the New Civil Liberties Alliance. He previously served as President and Director of Litigation at the Liberty Justice Center, where he litigated cases to protect economic liberty, free speech, and other constitutional rights. He served as a law clerk to Judge Cook on the Sixth Circuit. And finally, Ryan Walters is Deputy Attorney General for Legal Strategy in the Texas Attorney General's leadership team, where he's led the Attorney General's most significant litigation, including challenges to major federal rules. Before that, Ryan worked at the Texas Public Policy Foundation and in the Ohio Attorney General's office. We'll have our panelists walk us through the cases in the order that they will be argued, with the exception of 2 cases that I will briefly talk about at the end. The panelists will also take some questions after the main presentation, so we invite you to submit questions in the question and answer function at the bottom of your screen, which I'll note is different than the chat function. So with that, we'll start with our first 2 cases, West Virginia versus B.P.J, which will be argued on January 12th, and Little versus Hecox, which will be heard on the 13th. And Stephanie is going to tell us about both of those cases.
Thanks to the Federalist Society for inviting me to speak about these 2 important cases, both of which concern state laws that protect women's sports. And for full disclosure, I submitted amicus briefs on behalf of the Independent Women's Law Center, supporting the state petitioners in both cases. Before I go into the specific facts of the cases, I think it's helpful to briefly discuss Title IX. Title IX of the Education Amendments was enacted in 1972 to prohibit sex-based discrimination in education, including athletics. But because of the biological and physiological differences between men and women, Title IX and its implementing regulations explicitly allowed sex-specific sports teams. And the athletic regulations are indeed designed to ensure that women and girls receive equal opportunity in sports in educational institutions that receive federal funds, which applies to public, elementary, middle, and high schools, as well as essentially all colleges and universities, both private and public. And Title IX has been wildly successful in increasing athletic opportunities for women athletes. In the 70s, there were fewer than 300,000 sports slots for high school girls, and only about 1 in 27 girls participated in organized sports. But in 2018, 2019, there were over 3.4 million sports slots for high school girls, and over 3 in 5 girls participated in organized sports. This pattern has also repeated at the college level. During the 1971-72 school year, there were fewer than 30,000 women playing sports in college, which made up about 16% of college athletes. And yet during the 2023-2024 school year, that number reached over 200,000 women in college sports, which were over 40% of NCAA athletes, and they received about 45% of athletic scholarship dollars. So by any measure that you can count, Title IX has been wildly successful in encouraging women's sports. But in recent years, as I'm sure many of you are aware, women's sports have come under fire. We've begun seeing biological males who identify as female participating in women's sports at all levels, not just professionally, but also middle school, high school, and college. And when they do, these biological males displace women and girls, taking their spots on podiums and as well as on team rosters. In response to this phenomenon, 27 states have passed laws protecting women's sports, including West Virginia and Idaho, and that's where both of these cases start. So I'm going to start with West Virginia v. B.P.J. In 2021, the West Virginia legislature enacted the Save Women's Sports Act. The act provides that girls' sports teams are limited to girls, to females, as defined by reproductive biology and genetics, and regardless of gender identity. The act provides that sports can compete in boys as well as co-ed categories, and girls can compete in any category. B.P.J., a then 11-year-old biological male who identifies as female, sued West Virginia. B.P.J. sought to compete in the girls category for cross country as well as track and field, and argued that West Virginia's act violated both Title IX and the Equal Protection Clause because it discriminated against B.P.J. on the basis of sex as well as transgender status. The district court granted B.P.J. a preliminary injunction. West Virginia did not appeal that injunction. So for about 18 months, the act was enjoined as to B.P.J., who then went on to compete in the girls category for cross country and track and fields, frequently taking podium spots in both of those sports from what ended up being hundreds of young girls. The parties conducted extensive discovery, including expert discovery, and then they cross-filed motions for summary judgment. On summary judgment, the district court changed course, ruling in favor of West Virginia. It decided that the act was constitutional and that it did not violate Title IX, and dissolved its prior injunction. Much of its decision was based on the expert discovery showing that there are biological differences between men and women that give men a physiological advantage in sports, and thereby explaining or justifying West Virginia's decision to protect women's sports from male participation. B.P.J. appealed and also filed a motion for an injunction pending appeal with the Fourth Circuit. A divided panel of the Fourth Circuit granted that motion and again enjoined the act as to B.P.J. West Virginia asked the Supreme Court to vacate that injunction while the appeal was pending, but the Supreme Court denied that request over the dissent of Justices Thomas and Alito. So the case proceeded to the merits on appeal while that injunction was in place. The same divided panel of the Fourth Circuit ultimately ruled in B.P.J's favor on the merits. They vacated and remanded the district court's judgment on equal protection grounds. So they held that intermediate scrutiny applied because the act classified based on gender identity, because it, does not allow biological males who identify as female to compete in girls' sports. It held that West Virginia must defend the act as applied to B.P.J, who, because B.P.J transitioned pretty early, was placed on puberty blockers and did not undergo male puberty at all. The majority held that there was a material dispute regarding whether males who have, like B.P.J, who have not undergone male puberty, enjoy a meaningful competitive advantage over girls, and that is the question on equal protection regarding whether the act would ultimately survive intermediate scrutiny. The majority further held that the West Virginia's act violated Title IX by preventing B.P.J from competing on girls' teams. And on the Title IX claim, not only did they reverse the district court's grant of summary judgment to West Virginia, they actually ruled in favor of B.P.J on summary judgment. So the questions presented here are whether Title IX prevents a state from designated girls and boys sports teams based on biological sex, and whether the Equal Protection Clause prevents a state from designated girls and sports teams, girls and boys sports teams based on biological sex. So that the B.P.J case involves both Title IX and equal protection. Little v. Hecox is focused on equal protection. So in 2020, the Idaho legislature enacted the Fairness in Women's Sports Act, and it's similar to West Virginia's act, provides that women's sports are limited to women based on biology, not gender identity. Lindsay Hecox is a male who identifies as female and who desired to compete on Boise State University's women's track and cross-country teams, sued Idaho, arguing that the act violated equal protection in Title IX. Madison Kenyon and Mary Marshall, two women who ran on the women's track and cross-country teams at Idaho State University, intervened to help defend the act on behalf of Idaho. The district court here granted Hecox's motion for a preliminary injunction, holding that Hecox could try out for BSU's girls' teams, women's teams. Specifically, the district court held that the act discriminates on the basis of transgender status, and that the biological differences between men and women cannot justify that classification. Idaho appealed the preliminary injunction, but the Ninth Circuit affirmed, holding that laws drawing sex-based lines in school athletics were proxy discrimination on the basis of transgender identification, that transgender status is at least a quasi-suspect class, and that the act does not survive heightened scrutiny. There's an additional wrinkle in Hecox, in that Hecox has since filed a notice of voluntary dismissal in the district court, dismissing the claims, Hecox's claims with prejudice, agreeing that the preliminary injunction should be vacated. The district court actually granted Idaho's motion to strike that notice of voluntary dismissal, basically seeing it as an attempt to wrest jurisdiction away from the Supreme Court after it had granted cert in this case. But Hecox is still arguing in front of the Supreme Court that the case is essentially moot because Hecox no longer desires to participate in BSU's women's sports. So that is additional wrinkle there. There's a lot there. It's difficult to predict what the court is likely to do. I think it's clear that these laws protecting women's sports do classify on the basis of sex. The question, of course, is whether that is justified by the biological and physiological differences between men and women and the inherent physiological advantages that men have in sports. It's a trickier question whether these acts discriminate on the basis of transgender status. They were passed because of transgender females, males who identify as female, participating in women's sports and taking podium and roster spots away from women and girls. But neither of these acts draw lines based on transgender status. The lines are drawn based on sex. So it'll be interesting to see whether the court agrees with that. We saw in Skermeti last year that the court may be hesitant to find that a law discriminates on the basis of transgender status when the law on its face does not mention anything about transgender identification. So that'll be an interesting wrinkle, as well as in Skermeti, the court did not reach the question of whether transgender status or classifying on the basis of transgender status is a suspect or quasi-suspect classification. There were some justices writing on their own who said no, but the court as a whole has not reached that question. We also have Bostock, which was decided 2 terms ago, where the Supreme Court held 6-3 that Title VII of the Civil Rights Act protects employees from discrimination based on sexual orientation and gender identity, because that is a type of sex-based discrimination. So the court is going to have to wrestle with its decisions in both Skermeti and Bostock. And the consequences, if the court, it's possible that in Hecox, at least the court just moots it. But I think they have to reach the merits in B.P.J. There, we do have the additional question. So Hecox is a little bit more straightforward in that Hecox did experience male puberty and only went on puberty blockers and cross-sex hormones after experiencing male puberty. And the expert evidence on that is, I think, undisputable that Hecox would still have a physiological advantage in sports. The expert evidence is more mixed, where a child who has not yet experienced puberty is placed on puberty blockers. The district court agreed with West Virginia that there was enough evidence to justify West Virginia's Protect Women's Sports Act, but it's not quite as clear-cut of a question where the child has never experienced puberty. But I think that there's no jurisdictional issue there, and so the court is going to have to confront the Title IX and equal protection questions there, at least. And this has far-reaching consequences because, as I mentioned earlier, 27 states have enacted laws protecting women's sports, and an additional 2 states have protected women's sports through regulations or agency action. That leaves 21 states plus DC that don't protect women's sports. But if the Supreme Court holds that West Virginia and Idaho's laws are constitutional and don't violate Title IX, there is the question for perhaps next term about whether or not protecting women's sports violates Title IX or equal protection. And there are cases working their way through the lower courts now in California and other states brought by women and girls that feel that their equal protection rights are being violated by being forced to compete in athletics against males. So it's going to be an important set of cases, and I'm looking forward to seeing the oral arguments and how the court comes out on this.
Great. Thanks for your discussion of those cases, Stephanie. Next up is Ryan to talk about Gillette versus New Jersey Transit Corporation, and the court will hear this case on January 14th. Ryan?
Thank you, Tiffany. These are two consolidated cases from state high courts involving tort suits arising from injuries in Pennsylvania and New York from buses operated by the New Jersey Transit Corporation. As a disclosure, the state of Texas led a bipartisan multi-state amicus brief in support of New Jersey in these cases. So the question presented is whether the New Jersey Transit Corporation is an arm of the state of New Jersey for interstate sovereign immunity purposes. Interstate sovereign immunity is the immunity from private suit of a state in the courts of another state. So the two cases are Gillette versus New Jersey Transit Corporation from Pennsylvania, where the Pennsylvania Supreme Court unanimously held that the New Jersey Transit Corporation was an arm of the state of New Jersey and thus immune from suit, using a three-factor test that I will describe a little later, and reasoning that it must give primacy to the manner in which the sister state classifies and describes the entity within the structure of that state. So New Jersey's own definition of New Jersey Transit Corporation and the entity's functions were thus, quote, the driving force in concluding that New Jersey Transit is an arm of the state of New Jersey, unquote. The companion case is New Jersey Transit Corporation versus Colt from New York, where the High Court of New York examined the same three factors, but denied immunity, relying primarily on the fact that New Jersey is not formally liable for any money judgments against the New Jersey Transit Corporation. So what is the New Jersey Transit Corporation? Created in 1979, this separately incorporated entity operates New Jersey's statewide public transportation system. Its buses operate not only in New Jersey, but in Pennsylvania and New York. The legislature established New Jersey Transit Corporation as an instrumentality of the state designed to perform public and essential governmental functions. New Jersey structured its transit system as a body corporate and politic within the executive branch of the state government. The governor appoints all 11 voting members of New Jersey Transit's board, some of whom are removable at will and others for cause. The governor can veto any action that the board takes, and its actions do not take effect for 10 days to allow the opportunity to veto. New Jersey Transit Corporation has been delegated statewide governmental powers, including power to enforce all criminal and traffic matters at all times throughout the state, the power to promulgate rules with the force and effect of law subject to the State Administrative Procedure Act, and the power to take property statewide via eminent domain. Key to the parties' dispute here are statutory provisions that disclaim any liability of the state for any liabilities of New Jersey Transit Corporation and empowering the corporation to sue and be sued. But New Jersey Transit Corporation also relies heavily on the state for funding. The state largely forbids New Jersey Transit Corporation from incurring debt or selling bonds, making it reliant on appropriations from the legislature. And when it is sued, New Jersey Transit Corporation can demand to be represented by the New Jersey Attorney General. So what are New Jersey's arguments for immunity here? The Supreme Court, its 1977 case in Mount Healthy City School District Board of Education versus Doyle, set forth a three-pronged test to determine whether an entity is an arm of the state entitled to sovereign immunity. One, the textual and structural evidence of the state's own intent. Two, the state's control over the entity. And three, whether a judgment against the entity must be paid from the state treasury. New Jersey argues that the intent of the state is the most important, and the other factors largely serve to determine that intent. Key are the explicit statutory language deeming New Jersey Transit as a state instrumentality, placing it in the state's executive branch, and clarifying that it was created to perform public and essential governmental functions. The grant of statewide governmental powers also indicates the intent to make New Jersey Transit Corporation an arm of the state rather than a municipality. As to state control over the entity, New Jersey emphasizes the governor's appointment of the board of New Jersey Transit and the governor's appointments to the board of New Jersey Transit Corporation and gubernatorial power to veto all of its actions. On the third factor, while New Jersey is not formally liable for any judgments against New Jersey Transit, New Jersey emphasizes the practical reality that the state legislature covers New Jersey Transit's large operating deficits, making any judgments affect the New Jersey Treasury. And finally, New Jersey disputes that the mere fact of separate incorporation and ability to sue and be sued is dispositive against finding immunity for New Jersey Transit Corporation, arguing that some states have structured their entire cabinet departments as separate corporations and that sue and be sued clauses have been treated as relevant to waivers of sovereign immunity, but not to whether that immunity attaches in the first place. The Texas-led multi-state brief, the Texas-led multi-state brief argues that the Mount Healthy multi-factor test has created confusion, and New Jersey's intent to make New Jersey Transit Corporation a state instrumentality should be dispositive or close to it. Quote, federalism allows different states to create systems best suited to their own circumstances and policy preferences, including whether to treat different entities as arms of the state for purposes of sovereign immunity, unquote. The plaintiffs counter in two ways. First, citing the work of Professors Bode and Sachs, who filed an amicus brief in the case against New Jersey, they point to what they call the clear pre-20th century bright line rule that separate incorporation and the power to sue and be sued takes an entity outside of sovereign immunity, with a narrow exception for judgments that would directly act on the state. The evidence of early cases involving public banks are key, and they repeatedly held that such banks were not protected by sovereign immunity, even when fully owned and controlled by a state. New Jersey's express insulation from New Jersey Transit Corporation's debts makes clear that it should not be protected, and the governmental powers that New Jersey points to are little different from those of counties or municipalities, which do not have sovereign immunity. Second, plaintiffs argue that under the more recent Mount Healthy multi-factor test, New Jersey Transit still lacks immunity. On the first factor, the evidence of intent from the structure of the entity, plaintiffs argue that the fact of separate incorporation and its power to sue and be sued turns against such an intent. On the second factor, control by the state over the entity, plaintiffs argue that New Jersey lacks any power to affirmatively direct New Jersey Transit to take any actions, and a mere veto by the governor is just not enough. Similarly, showing lack of control is the limit of gubernatorial removal of a majority of the New Jersey Transit Board members to the for-cause standard. On the third factor, most importantly, the express limit against any judgments against New Jersey Transit Corporation being enforceable against the state's treasury is dispositive, with plaintiffs arguing that case law shows that practical consequences of a judgment against the state treasury are irrelevant. Aside from the concrete effects of the outcome of these cases, a big picture issue lurks in the background here. To what extent should a Burger Court multi-factor balancing test be replaced by the original meaning of interstate sovereign immunity, or in the alternative, by a more predictable rule? I look forward to any questions about these cases.
Thank you, Ryan. Next up is Brad to tell us about Wolford versus Lopez, which the court will hear on January 20th.
Thank you. And I must start by complimenting Ryan for talking about a multi-factor Burger Court test. Eventually, in the next 10 or 20 years, we won't have any of those to kick around anymore, I hope. Wolford versus Hawaii is a Second Amendment case. My firm did an amicus brief for Calguns Foundation and the Center for Human Liberty in support of the challengers. Wolford's story begins with the court's Bruin decision in June of 2022. Bruin was the case that dealt with so-called may issue licensing rules for carrying firearms in states like a small minority of states, New York, New Jersey, California, Hawaii, and just a few others. Under these may issue regimes, citizens had to show a special need for carrying in order to get a license. And as a result, basically, no one could get a carry license except for friends of politicians and celebrities. The court in Bruin said, no, ordinary citizens have a general right to carry without having to make any sort of special showing. The court stressed that term, a general right to carry. In light of that ruling, all may issue regimes went away. But these blue states weren't happy. They were not happy that their rules had to be changed. So they immediately enacted so-called Bruin response bills. And these bills had a few things in common. The primary thing they had in common was that the anti-gun states changed their laws by designating a whole bunch of new places as sensitive places where guns could not be carried. All of a sudden, places like churches, public transportations, basically any public gatherings were considered sensitive when they hadn't been considered sensitive for 200 years, but they immediately became sensitive after Bruin came out. There's been a flood of litigation about this, and we're hopeful the court will take up that issue in the next term. The Wolford case, however, deals with a different response to Bruin. Hawaii, like California, New York, and New Jersey, changed its law to say that for private property held open to the public, it's a crime to carry firearms on that property without the affirmative consent of the property owner. For those changes to those few state laws, as with every other state, the default rule was that you can carry firearms onto private property held open to the public unless the property owner forbids carry. It's common, for example, throughout the country to see signs at places like Costco and other chains saying no firearms allowed right at the front door. Under Hawaii's rule, if a store doesn't say guns are welcome or otherwise consent, it's a crime to carry there. The plaintiffs in Wolford sued and said the effect of this law is that we can't carry anywhere we go on a normal day. The gas station, the grocery store, the bank, a shopping mall, etc. In other words, we do not have a general right to carry as was guaranteed to us in Bruin. And indeed, that was the whole point of Hawaii's law. When it adopted the law, Hawaii cited an article from 2020 by a law professor named Ian Ayres, who said these default rules should be changed because property owners will follow whatever the default rule is, and this will be an easy way to disarm people. In fact, it might become so inconvenient for people that we can only hope that people will just stop buying guns. I mean, that was like right in the article. And social scientists, in fact, have been writing for years that when people have a choice of how to act within a system of rules, the easiest way to get them to change their behavior is to change the default rule in the direction the rule setter wants to guide them, because the power of inertia is so strong that people follow whatever the default rule is. And this school of thought or school of social science has a classic name. It calls itself libertarian paternalism, because it preserves choice, but the choices are being guided in a paternalistic way. And the only way I know this is because we did our amicus brief. In any event, Hawaii says here, consistent with that theme, we aren't preventing anyone from carrying. It's not against the law to carry on private property. It's just that the property owners these property owners are deciding not to take affirmative steps to allow it. So that's the backdrop. Under Bruin, the question becomes, can Hawaii demonstrate that this law is consistent with the nation's history of firearms regulation? In order to justify modern firearms restrictions, Bruin says that states must be able to point to a similar or analogous regulations that predominated at and around the founding. Or as the court said in the Rahimi case a couple of years later, is there an underlying principle in the nation's historical regulations that justifies a new regulation? Well, when it came to New York and New Jersey's similar laws flipping these default rules, the Second and Third Circuits said there was no historical tradition that justifies these new regulations. They found that they violated the Second Amendment. The Ninth Circuit created a split and upheld Hawaii's law. It mostly relied on a few founding era laws that said people had to get the consent of landowners before they could hunt on their farms if the farms were enclosed. In other words, if they had a fence. To which Wolford responds, this is hardly analogous to a complete and total bans on carrying in private property held open to the public unless the property owner consents. As a side note, the hunters out there may already know this, but there's a long tradition in the US that says when it comes to hunting, people aren't engaging in trespassing when they enter someone else's land to hunt unless the owner puts up a fence or posts a sign. In other words, in the vast majority of cases at the founding and for at least 150 years later, farms were not enclosed by a fence. So people were free to hunt on that land. And I would give a shout out to Cooper and Kirk for a very interesting history lesson in their amicus brief on how American law differed from English law in this. And I would look for the court to pick up on this distinction. One other interesting thing to watch out for, because this rule is just kind of unusual and indirect, the Solicitor General's office filed an amicus brief inviting the court to say this law was just obviously enacted solely for the improper purpose of negating the right to carry, so it's just invalid on its face. And that's an unorthodox argument under Heller and Bruin, and I would be surprised if the court goes down that road here. I'm hopeful that won't be needed. It's a fairly straightforward proposition under Bruin to say this law is a total historical outlier and violates the Second Amendment. Nevertheless, it's a very important case because so far only one other Supreme Court case, the Rahimi case, has applied Bruin, and there is a huge number of cases out in the district and circuit courts challenging all kinds of restrictions. So many cases will be picking apart every word of the Wolford case when it comes out. Thank you.
Thank you, Brad. Up next is Jacob to tell us about Trump v. Cook, which the court will hear on January 21st.
Thank you. Trump versus Cook is about the president's ability to fire members of the Federal Reserve's Board of Governors. In August, President Trump announced in a Truth Social post that the administration had uncovered evidence that one of the Fed's governors, Lisa Cook, had lied on a mortgage application shortly before President Biden appointed her to the board in 2022. Allegedly, she claimed two different residences as her primary residence on two different mortgage applications on different properties. And of course, only one of those could actually be her primary residence, giving rise to the assumption that she was lying in one or the other. 5 days after that post, President Trump announced in another post that he was firing Cook for that reason. Cook then filed a lawsuit in which she argues that federal law only allows the president to fire a Fed governor for cause, and her alleged lie on a mortgage application before she took office was not a valid cause because it didn't relate to her performance in the job. She also argues that her firing violated due process because she didn't get a hearing at which she could defend herself. Trump argues that actually lying on a mortgage application is a good reason to fire someone who's responsible for overseeing the nation's banking system, and that she wasn't entitled to any process. And if she was, she got all the process she was due. The federal district court in D.C. sided with Cook and issued a preliminary injunction blocking her removal on both grounds that she raised. The D.C. Circuit affirmed on the due process grounds only over a dissent by Judge Katsas. And so now the Supreme Court is going to consider Trump's application for a stay of the preliminary injunction at the hearing on January 21st. As I said, the legal arguments in the case are about whether Cook's alleged misconduct counts as cause under the statute and whether Cook was entitled to due process and, if so, received the process she was due. On the cause question, Cook argues that cause means only inefficiency, neglect, or malfeasance in office, even though the statute doesn't spell that out. Trump argues for a broader reading of cause that would encompass, among other things, unfitness for office or the president's loss of confidence in the office holder. And he says that courts can't review a president's determination that there is cause to fire the governor. He admits that you couldn't fire her for a mere policy disagreement or simply because the president wants to have somebody else in the office. But otherwise, if the president identifies a cause, the office holder shouldn't be able to challenge that. Also, Trump argues that Cook's idea that she can't be fired for any conduct that occurred before she took office would lead to absurd results. Like if she bribed a senator to vote to confirm her, or if she murdered someone before taking office. Well, Cook's argument, Trump says, would mean that the president couldn't remove her for those things. And Cook's response to that is, yeah, that's right. The law says that that means that it's only for these things in office. And if there's some other reason why she should be removed, well, Congress just has to do that through impeachment. That's the law. On the due process issue, Cook says she was entitled to a hearing. Trump says she wasn't entitled to anything because you're only entitled to due process on under the Constitution if the government deprives you of a liberty or property interest. And officers of the United States don't have a property interest in the offices that they hold. Cook points to cases where the Supreme Court held that certain government employees had a property interest in their employment. And Trump responds to that by saying, first, those cases don't have anything to do with the original meaning of the Due Process Clause. And in any event, the Supreme Court has never said that officers of the United States, as opposed to just employees, have a property interest in their offices. And in fact, it's said the opposite. Cook also argues that the statute gives her a right to due process implicitly through the for-cause requirement. And to that, Trump says Congress knows that it can require due process before removing somebody. It has done that in certain situations for certain offices, but it didn't do so here. Trump also argues that regardless of the merits, a district court doesn't have the power to issue a preliminary injunction to keep somebody in an office. Trump says the only remedy for that is, for an improper removal, is back pay. And Cook responds to that by saying, no, courts' equitable powers allow them to preserve the status quo by keeping someone who's still in office. And for that, Cook cites one 19th century treatise on injunctions and one 19th century Ohio Supreme Court case. So those are the arguments, the legal arguments the parties are making. But in the background of all this, and something the court might well ask about an oral argument, is a case the court heard last month, Trump versus Slaughter. Slaughter is about whether the president can fire an FTC commissioner without cause, even though there's a federal statute that says he can only fire an FTC commissioner for cause. And there Trump argues that Congress can't restrict the president's authority to fire FTC commissioners at all because Article 2 of the Constitution vests all executive power in the president. And if the president can't fire somebody who's exercising executive power, That means the president doesn't have all the executive power. He's sharing it being forced to share it with somebody he doesn't want to share it with. He also argues that the president can only fulfill his duty to take care that the laws are enforced under Article 2 if he has ultimate control over everybody who enforces the law. It's widely believed that the court will rule in Trump's favor in Slaughter, rightly in my view. The other side in Slaughter, though, has warned the court that Trump's argument there would mean that the president could also fire members of the Federal Reserve Board without cause. And that's supposed to be unthinkable. That's supposed to make the court conclude that, well, then Trump can't be right about all this, because if it means he can fire Fed governors, then it's just unacceptable. We can't have that, because the Fed's independence is so important. If the president could fire Fed governors at will, well, then he could control monetary policy. He could make the Fed have easy money policies that would might work to his political benefit in the short term, but lead to inflation and economic disruption in the long term. And in the Cook case, Cook and some of her amici have made a similar argument. They said you have to rule in Cook's favor, and there has to be a really strong, narrow for-cause requirement, because it's so important that the Fed remain independent. At the Slaughter argument, John Sauer, the Solicitor General, brushed these concerns aside and said it doesn't necessarily follow from their argument in Slaughter, because the Fed is different. It has a special status, supposedly, because we had the first and second banks of the United States in the 19th century, and pretty much everyone agrees that those were constitutional, even though they were independent. So the argument would just at least be different there. Now, in our amicus brief for the New Civil Liberties Alliance, we say no. In fact, the Fed exercises executive power, and the president should be able to fire its governors. The Fed governors don't just manage the money supply. They regulate banks, they enforce regulations, they impose fines on people for breaking the law. And that's an exercise of executive power. And that means the president has to be in control of it. The Constitution doesn't establish a fourth independent branch of government to handle money and banking. Some people might think it should have, but the fact is that it doesn't. And that doesn't mean, we point out in our brief, that the Constitution then just dooms us to presidential control over money and all the bad things that might flow from that. I don't have time to get into that, but we make that argument. But in any event, it's simply not in the Constitution that that you get to have a Fed that the president doesn't control. Anyway, I expect the court would prefer not to get into any of that in the Cook decision if it can help it, and I suppose it can and likely will avoid it, especially if it agrees with the president that he had cause under the statute and that she wasn't entitled to due process. Then it's just all decided on statutory grounds and due process grounds, and that's the end of it. And I think that's a likely outcome, mainly because I think Trump's arguments are pretty good. And if they were good enough for Judge Katsas, there's a good chance they'll be persuasive to at least 5 of the conservative justices. Or maybe, I don't know what the chances are, but maybe they'll agree that a court just can't keep someone in office with a preliminary injunction and then skip the merits of the rest entirely. What if they do address the merits and they think that Trump didn't have cause under the statute? Well, then Article 2 might come into play, because the court could consider that he has the power under Article 2 to fire her without cause and due process anyway. So therefore, it's okay despite the statute and any due process concerns that would otherwise exist. I think that they're not likely to do that, even if they, again, agree with Cook about the statute, because Trump didn't raise the Article 2 argument. We did, but he didn't, and I'm guessing they would hold him to the arguments that he made. I think they're more likely to address the relationship between the president's Article 2 powers and the Fed in Slaughter, at least to say the Fed might be different because of the unique histories around banking, or maybe in Slaughter they'll even just say that it is different. Although I would hope not, because I think that's wrong, and because the court shouldn't bless such a departure from the structure of government and the separation of powers spelled out in the Constitution when it doesn't have to, and when that hasn't been fully briefed. And even if some justices agree with Trump and Slaughter and agree with us about the Fed, my guess is that they would rather save that for another time, maybe never. But those are just my guesses, and we'll find out more about what's on their minds with respect to all this on the 21st.
Thank you, Jacob. I will tell you very briefly about the two remaining cases this term, but as a reminder, if you have any questions for the panelists about any of the preceding cases, feel free to drop those in the question and answer box at the bottom of your screen. So the first case I have is Chevron versus Plaquemines Parish, and if you're from Louisiana, forgive me if I butchered that name. Which the court will hear on January 12th. So this case involves a dispute over when a federal contractor can remove a case from state to federal court. In this case, a group of Louisiana parishes sued the petitioners, which are Chevron, Exxon, and some other oil companies, sued them in state court for their production of crude oil in the Louisiana coastal zone during World War II. So petitioners removed these cases to federal court under a statute that provides federal jurisdiction over civil actions against any person acting under an officer of the United States for or relating to any act under color of such office. A panel of the Fifth Circuit held that petitioners satisfy the statute's acting under requirement by virtue of their World War II era contracts to supply the federal government with high-octane aviation gas. But the panel split on the relating to requirement, which the majority held that the petitioners' wartime production of crude oil was unrelated to their contractually required refinement of that same crude, because the contracts didn't contain any explicit directive pertaining to the petitioner's oil production activities. So the questions presented in this case, there are two of them. The first is whether a causal nexus or contractual direction test survives this federal removal statute. And the second question is whether a federal contractor can remove to federal court when sued for oil production activities undertaken to fulfill a federal oil refinement contract. And then our final case is M&K Employee Solutions versus trustees of the IAM National Pension Fund, which the court will hear on January 20th. This case involves everyone's favorite topic, ERISA, which is the Employment Retirement Income Security Act, and it imposes withdrawal liability when an employer withdraws from an underfunded multi-employer pension plan. They provide this in order to cover the employer's share of the plan's underfunding. So the statute provides a detailed framework to compute the withdrawal liability and instructs that it must be computed, quote, as of the end of the plan year preceding the plan year in which the employer withdraws, end quote, and not as of the day of the withdrawal. So the question presented here is whether, despite that instruction, the plan may base withdrawal liability on actuarial assumptions that are adopted after the prior plan year and that contradict the assumptions it found reasonable and appropriate at the end of the prior year. The DC Circuit held that a plan may do so, but it recognized that there is a circuit split over the issue. And with that, I think we have a couple of questions here. Stephanie, I think this one is for you. One of the questioners asked about the oddity of the argument that laws protecting women could be argued to violate Title IX. They ask, Title IX actually require the protection of women to allow them to fully participate on a fair playing field?
So I think that that's right. That's not presented in either B.P.J. or Hecox, but there are cases working their way up through the lower courts, making that argument that Title IX does require the protection of women's sports. To be fair to B.P.J., the argument is so Title IX forbids discrimination on the basis of sex. And the provision that B.P.J. is pointing to has the same language as the Title VII provision that the Supreme Court interpreted 2 terms ago in Bostock. So B.P.J. is pointing at that language and pointing at what the Supreme Court did in Bostock and saying that because it's the same language, it should be interpreted the same way. And therefore, Title IX also prohibits discrimination on the basis of gender identity or transgender identification, essentially. B.P.J. also argues that because B.P.J. transitioned so early, if I'm recalling correctly, at the age of 8, and went on puberty blockers, and fully lives B.P.J.'s life socially as a girl, that if B.P.J. is not permitted to participate in any girls' sports, then in practicality, B.P.J. is not allowed to participate or will not be able to participate in any sports because for social reasons, medical reasons, because of the puberty blockers, that B.P.J. just can't participate in boys' sports. And that therefore, as applied to B.P.J. and B.P.J.'s particular circumstances, Title IX prohibits the state from preventing B.P.J. from participating in girls' sports. West Virginia's response to that is one that Bostock's interpretation of Title VII is limited to Title VII, and the Supreme Court said that Title VII that its decision there shouldn't be interpreted more broadly, and that also what B.P.J. is doing is essentially arguing that West Virginia needs to interpret the word sex to mean gender identity and not biological sex, and that there's nothing in Title IX or the Constitution or anywhere else that would force the state of West Virginia to interpret sex to mean gender identity and thereby allow B.P.J. to participate in girls' sports. So, I mean, at least 2 out of the 3 panelists on the Fourth Circuit agreed with B.P.J. here. Judge Agee dissented and agreed with West Virginia. I think West Virginia has the better of the argument, but the Supreme Court is going to have to contend with its decision in Bostock. Maybe it just cabins it to Title VII as it suggested that it was going to do. But it's not quite so straightforward. And how they decide to interpret Title IX will have downstream effects, not just on the 27 states who have passed laws protecting women's sports, but also on the remainder of the states who either don't have such laws or have explicitly allowed this, because of the other cases that are working their way through.
Great. And I see one person ask in the chat about timing of these decisions, asking whether these might not be decided until the end of June. While we can never predict exactly what the court's going to do, I think that's a fair assumption for some of these cases, given that they're the most hot button, some of the most hot button issues of the term. But do any of you have any thoughts about that?
I agree, at least for B.P.J. and Hecox. I would be surprised if we heard back from the Supreme Court on these earlier than June, but as you said, we'll never know for sure until they come out.
And then Jacob, a question for you. The questioner asked, do you agree agencies wield legislative power in this case? And if they do, the questioner asked, isn't the answer to simply pare back agencies' legislative action and force Congress to craft laws that are more specific and intelligible?
Yes, and yes. Agencies absolutely are engaging in legislative activity when Congress gives them broad, vague grants of authority, and then they start enacting regulations that are the law that people have to follow. They are engaging in a legislative role there, and it's very important that the Supreme Court would pare that back too. You're absolutely right. And there's some people may be concerned that these agencies have so much power right now. And if you put the president in charge of all of them, as Slaughter would suggest, then that gives the president maybe a scary amount of power because they have so much power. Now he's in charge of all of it, and that's one person directing all of that. Well, the answer to that isn't to not give the president the power the Constitution requires him to have. The solution to that is to enforce the separation of powers across the board and not let Congress delegate its legislative power to these agencies to the extent it has. So the court absolutely should rule in Trump's favor in Slaughter, but in every opportunity, it should also pare back the administrative state by reducing its ability to effectively legislate, as you say.
Thank you. Well, no, I think that wraps us up. Thank you to our panelists, to the Federalist Society for hosting this event, and to all our viewers watching online. We hope you join us in February for the next Seat at the Sitting.